On venue, first, in light of post-briefing developments, I think it's important to note that this court should review the venue determination based on the pleading that was in front of the court at the time it made its venue determination. And I'd point the court to In re Hardwick, which is 426 Southwest 3rd at 157 to 158. For the most on-point case on this, and it contains a pretty thorough discussion of this, and is a similar situation where there was a review of a mandatory venue issue was pending. Plaintiffs amended their pleading to try to defeat that mandatory venue issue, and the court made clear that their scope of review extends only to the trial court's venue determination that is the ruling challenged in the original proceeding. And that also has its roots in Rule 87 itself, which
Read that citation again.
Yes, Your Honor. In re Hardwick, 426 Southwest 3rd at 157 to 158. And Rule 87.5 states if an action has been transferred to a proper county in response to a motion to transfer, then no further motions to transfer shall be considered. So it envisions only a single venue determination. And so that's why courts look at the pleadings that were in front of the trial court when it made its determination. And on that pleading, our position is that the state cannot maintain venue because they failed to allege a claim for relief under the DTPA. In Section 17.47B, the venue provision of the DTPA specifies that venue can only be invoked in an action which alleges a claim to relief. So in order to maintain venue, you have to properly plead a DTPA claim. And I believe the state agrees with us on this. On page 2 of their response, they write, and I quote, "Venue is proper in Tarrant County because the state has adequately alleged DTPA violations by relators and sought a legal injunction based on that statute, which authorizes venue in Tarrant."
Do you agree if they pleaded a cause of action properly, then venue would be established in Fort Worth?
No, Your Honor. We also have another issue, which is that the injunction statute is a mandatory venue provision that would override the DTPA provisions. But this court, if Your Honor's find that they did not properly allege a claim, then it wouldn't need to reach that legal issue.
Let's do them just one at a time.
Sure.
Beginning to run together.
Sorry.
So what's your argument on prior restraint?
On prior restraint, as this court preliminarily noted in its order, the order is a pure restraint of speech. The first point in the order is restraining political fundraising. And
so if somebody was raising funds, saying, raising funds, I'm running for Congress, and using them for their mortgage, could the Attorney General do anything about that? Is that a deceptive act?
Not under the DTPA. If it's just a general...
Sounds deceptive to me.
It may be deceptive, but in order to be a transaction under the DTPA, it has to be a transaction in trade and commerce. So there's other other legal violations that would be implicated by that. Private actor might have a fraud claim.
Well, as we noted in the earlier order, is this a personal expense when you're, I guess, first of all, do you concede that the lawmakers were absent without leave?
Yes, I believe.
I think you have to.
Yeah, it's in the.
There's a provision of where you get leave, and they didn't get that, and so they're AWOL. Now, does that make it then? If they're staying in fancy hotels, that make it a personal expense, or did they have to stay in crummy hotels, so it's political expense, or do we look at what their motivation was, which appears to have been political, or what the spending was, which is for cost of, same thing I have to pay for when I travel to Chicago.
Well, Your Honor, first of all, the only evidence in the record is a declaration by Mr. Wysong that there were no transfers of funds or other benefits to the legislators. But even if that were not the case, to be frank, I don't know if it is or is not. I think that would be a complicated legal issue on its own, but it would implicate the provisions of the election code that prohibit personal expenditures. It wouldn't be a Deceptive Trade Practices Act. If all that's on the front end, it's just pure gratuitous donations to an organization.
And could you also address the state's point that the TRO issue is totally moot now?
Yes, Your Honor. So it is not moot because the state is actively seeking to hold the relators in contempt of court for having violated the TRO while it was in place. And they specifically point in their motion for contempt to basic fundraising speech, at a rally stating fight for Texas Democrats and general fundraising appeals of that nature. So they're actively seeking them to hold them in contempt. Also on paragraph 43 of their second amended petition, which they're saying moots the TRO mandamus, they are using it as a basis to seek quo warranto of Powered by People, so to seek the corporate death penalty against Powered by People for having violated allegedly that temporary restraining
Make
order.
those arguments in those cases. One could wonder whether it's easier to win that argument when it's by contempt, because contempt, it's got to be absolutely clear. It's a higher standard of proof required to hold somebody for contempt. Probably also for quo warranto, though, we hadn't had many of those cases for the last 100 years, so it's kind of up in the air.
Perhaps that would be true on the ultimate, I guess there might be a higher standard of proof on the ultimate merits question, but just on the issue of whether the TRO was an impermissible prior restraint and therefore void, and also whether, as this court pointed out, it does not meet the requirements of Rule 680 and so is void. And courts have held that under these circumstances where there's a pending contempt proceeding, that it is proper mandamus review of a temporary restraining order is proper, even though the temporary restraining order has expired, for instance.
So we're getting pretty far in. I'm interested on the venue question. That was the first thing that was argued at the below. I agree with you that the Section 15006 of the Civil Rights Remedy Code says the venue depends on the facts when the claim accrued. So if they sue you in Potter County because you lived in Potter County, you can't move to Randall County or something else and defeat it. But your claims can always be amended. And that can't apply to claims, because it's when the claim accrues, you haven't made any claims yet. They don't exist. And of course, under Texas law, you can amend your claims to drop stuff all the time. If you want to get out of a particular, you don't like the way they're trying your case in Harris County, you can dismiss your claim and refile it in Brazoria County. Why is it you can't drop the claim and that takes away the mandatory venue argument of they're taking an injunction?
So I would agree, Your Honor. If this was at the trial court, they could amend their pleading, and that's why the trial court's venue ruling, you can look at the first amended pleading, which was in front of the trial court. But after it's already on review, the order that is being reviewed was the trial court's venue.
We're not supposed to review TROs at all. We're not supposed to review venues at all. The exception is mandatory venue. But if the sole reason for mandatory venues and injunction, we can take judicial notice that they're not pleading it anymore. So we can't do anything on transfer. Now you can win if you go back down and you lose everything. It's an automatic reversal if venue in Tarrant County was wrong. But, you know, we've already written on this, and it's one of the oddities of Texas law. You just can't get review of a TRO. So I'm wondering how you tell us, what is it you tell us that allows us to do that?
To clarify, Your Honor, are you talking about review of the TRO or review of venue or both?
Review of venue,
Okay.
which, you know, I think that's I mean, there's two reasons we're not supposed to review TROs, and we're not supposed to review venue rulings. You're supposed to take those up on final appeal.
So on the venue issue, Your Honor, again, I would point you to the In re Hardwick case, also to
I've got that as a Houston Court of Appeals,
it is, Your Honor.
which is binding on us because
It is not, but I believe the logic there is still
they
sound.
address the
And
difference between can you amend your claim, and you can't change the facts from when it accrued, but you can change the claim.
they brought in they changed their allegations to bring in it's not a legal claim, but to introduce a forum selection clause that had not been in front of the court at the time it made its ruling.
I can see not, you know, sandbagging the trial court with something they didn't have a chance to see. But this wasn't a sandbag case. Everybody, you know, you all made the argument that it's an injunction, mandatory venue, you know, in El Paso County, etc. But if they've dropped that claim and it's not a case of manipulation, they concede the people aren't out of state anymore. I hear your argument on, yeah, but they haven't let go of the penalties. I understand that, but of course, we don't have an mandatory exception for civil penalties.
So believe that it is also in keeping with the intent of Rule 87, which envisions only a single venue determination. So I do think that the In re Hardwick court's logic applies in this situation. Further, on the TRO reviewability, I'd point the court to In re Cornyn, which is 27 Southwest 3rd at 332 and note 11. And that addresses the review of TROs that are the other side argued were moot, but there was a pending contempt proceeding. And so the court went ahead and reviewed that TRO. And then on the venue issue, if the court does review or grant mandamus on the TRO, it would also be proper to grant mandamus review of a permissive venue ruling. So in General Motors Corp v. Gale, that's at 951 Southwest 2nd, 469, and also In re Colonial Pipeline, 968 Southwest 2nd, 938. And those are both Texas Supreme Court cases. They their holding was that it's proper to review an incidental ruling that is not otherwise reviewable on mandamus if the court is granting mandamus review on another issue, that judicial efficiency and administration, sort of go into the balance of the benefits versus detriments of mandamus review.
Time flies when you're having
Oh.
fun.
Yes, Your Honor.
Thank you very much. Mr. Stone?
May it please the court. Powered by People told Texas consumers that their political contributions were going to lawful political causes. That was false. The money was instead used for unlawful purposes to pay for the personal expenses of absconding Texas legislators.
What says that? Says that's personal.
Well, Your Honor, it is personal because it was paying for their food.
No, I know what it was paying for. I'm looking for somebody. But are we going to be the first ones that has to say when you're AWOL, if you want to eat or stay at a hotel, that's an improper use of political contributions? That's sounds like something the Ethics Commission or the House itself ought to decide.
Well, Your Honor, the Ethics Commission has concurrent jurisdiction to look at this from an ethics commission perspective. But here we've alleged a DTPA violation. Here we're
Where's the
alleging that
consumer, though, that what it, you, to have a DTPA violation, that there still has to be a consumer.
no, there doesn't. We are not required to have a consumer for a claim brought by the state under section 17.47. When the state,
I mean, the AG can bring a claim without a consumer, but it still has to be a consumer transaction. So where is the consumer transaction?
we are not required to have a consumer transaction under the DTPA. So under section 47 or 17.47, the state brings causes of actions not in a private capacity like section 17.50. Instead, we bring lawsuits on behalf of the public interest. So we don't need consumers and we don't need transactions. Under section 17.46A of the DTPA, the state is, which only applies to the state, we are allowed to bring lawsuits when there is a false, deceptive, or misleading act or practice in trade or commerce. It doesn't say a transaction. Indeed, the DTPA allows us to bring suit if there's advertising. If there's false or deceptive advertising, whether or not there's a subsequent transaction, we can still bring a DTPA lawsuit on behalf of the state in the public interest.
What's the trade or commerce?
The trade or commerce here, the DTPA defines trade or commerce. Here, the trade and commerce includes advertising as well as the distribution of anything of value. Here, the thing of value being distributed is the crowdsourced funds that the relators were gathering, as well as the advertising that relators were doing around the collection of those funds. They were telling consumers, we are gathering, or we'd like you to donate funds to our campaign. We are going to use it for a lawful purpose, and then they used it for an unlawful purpose. This is much like our Cancer Fund of America case, which we cite to, I believe we cite to in our brief.
What was the evidence before the trial court that there was actually a statement made that said we will use this for a lawful purpose? And then what was the evidence that it was being used for an unlawful purpose?
Well, in the second amended petition in paragraph 36, we allege that they represented that the funds were going to be used for a lawful purpose. The court can also look to paragraphs 26 through 27 and 33 about the where we allege that the funds were instead used for an unlawful purpose. That is in violation of the election code for personal use by the legislators, as well as a quid pro quo, which we talk about in paragraph 13 of our second amended petition.
I guess my bigger concern here is that this operates as a prior restraint. And we have binding Texas Supreme Court precedent that governs what you have to show to be able to get a prior restraint on speech. And I mean, going all the way back to the founding, prior restraints were very much disfavored in federal law. They're also very disfavored in state law. And I don't believe the TRO had any explanation of how you meet the Texas Supreme Court's prior restraint factors, did it?
And in answering that question, if you would go back to her first question as well, because you cited the pleadings, but the pleadings aren't evidence on a TRO. So what is the evidence that supports what Justice Ferris asked?
The pleadings are evidence on a TRO. TRO is decided, a temporary restraining order, based on the verified pleadings. A temporary injunction requires us to present evidence. That's where we have the live hearing. That's where we call witnesses. We put forward evidence.
Do you have a case that says that?
Your Honor, I can provide a supplemental, but it's in the statute. The statute itself for TRO, chapter 683 says that it's decided based on the verified pleadings and the affidavits. That is the standard for a temporary restraining order.
The restraining order itself has to have justifications, right? And it's also got to have an analysis of the Texas Supreme Court factors for prior restraint, doesn't it?
So to the issue of the prior restraint, we do not concede that there's a prior restraint on speech because there's lots of case law that says when you're dealing with a false or deceptive statement, that is not protected speech. And for us to get into the prior constraint, first there has to be protected speech for which we are restraining. Here, because the statements made were false or deceptive, there is no prior restraint that is invoked here. And our best case for that, I think, for the court would be the mothers and unborn babies case, which is a perfect example where the state brought a DTPA lawsuit against a crisis pregnancy center. They argued in response that they were offering a free service. and that they were protected by the First Amendment. And the Supreme Court, Texas Supreme Court, held that false or deceptive statements are not protected by the First Amendment. We also have United States Supreme Court case law that we cite to in our brief that discusses how false, deceptive statements are not protected speech. So we don't think there is a prior restraint on speech at all here. The TRO was also narrowly drawn. You can look at the statements made by Robert Francis himself, who said that it was exceedingly narrow and he understood exactly what was being commanded of him, and that it didn't prevent him from holding rallies, it didn't prevent him from raising money, and it didn't prevent him from speaking. So this was an exceedingly narrow temporary restraining order.
So why are you moving for contempt?
Well, Your Honor, we're
What
moving.
did he do that was contemptuous?
He said first he publicly announced that he won the TRO and that there wasn't a TRO, so he announced that publicly. Then he said, F the rules don't matter, in response to the court's temporary restraining order. And then he went ahead and violated the temporary restraining order by making the very statements.
We've got a specific Supreme Court case that says F the draft is protected speech. And so F the rules is different because.
Well, it's a different issue. The issue is that
Probably it's the different words are used except the expletive at the front of them. But why is there a constitutional difference that one is speech and one isn't?
So because they're different issues in that the temporary restraining order sought to prevent violations of the DTPA. In other words, to prevent the relators from making misrepresentations to consumers about what the donations were going to be used for. The contempt proceedings were for relators not complying with the TRO. So those statements that they made, like F the rules, that relates to the compliance with the TRO, not the underlying violation of the DTPA. So
If the TRO is narrow, it still sweeps in a statement as kind of generic as F the rules.
F the rules isn't. It's the disdain for the courts and it's the disdain for the TRO. The actual violation of the TRO order was holding the rally and then making exactly the same statements that we're going to keep raising money, we're going to keep doing with the TRO.
Thought for just a second. Speaking of disdain for the courts, I want to talk about I understand things were happening very quick. And we're being asked to do things quick. You're being asked to do things quick. But when you file something with the Supreme Court saying the 15th Court's breakneck briefing schedule was patently unreasonable, violated due process, and further supported by the exceptionally busy schedule of the state's lawyers, the 15th Court's expedited briefing schedule flouts the basic guarantees of due process, deprives the state of its opportunity. The state lawyers are exceptionally talented, hardworking, which I'll go on record and say that has been my experience. Except your also staff is 100 times bigger than our staff. So I'm very sorry that we gave a short thing. We also took it back, and as things in the ether would have it, we granted a 14-day extension, which you also complained about, which I think is contrary to your complaint that we're doing things too fast. We granted a 14-day extension, technically a minute before you filed in the Texas Supreme Court, accusing us of, among other things, we cannot disrupt the lives and work of attorneys for parties before it. Now, your name wasn't on that. I got that, which I'm wondering if that's why you got the black beans who come show up before us. But the thing that troubles me, of course, we're a brand new court. And in the world I grew up in, which was another age and generation, you wouldn't say stuff like that about a court that you were going to have to appear in front of. Your colleagues have to appear in front of us all the time. And is somebody over there, if not, is there somebody you can talk to, say, look, we need somebody to read stuff before we file it and see if, in fact, this problem is about to disappear. So we're saying some pretty strong stuff that, in fact, there's, as far as something you didn't know yet, is no longer true. And frankly, it's just hard to take things like that back. So Do you want to comment on that or?
Yes, Your Honor, I will take that back to the office and share that with my colleagues, and I'll just share with the court what our mindset at the time was. Our friends on the other side sought
Now,
mandamus.
that's the other thing. If you're going to say that about the court, don't call them your friends. They're not your friends. They're the other side. And you want to call them some of these names, you would probably get in just as much trouble as calling the court some of these things.
And I'm not going to say anything
We're your
demeaning
friends
about them.
too.
You are our friends, Your Honor. I just want to give you a brief preview into what our mindset was. There were 8 separate motions. I think it was 8 or maybe 9 separate motions, and I think we had 24 hours to respond to them. So there was a sense of urgency and concern to respond so quickly.
It was designed to let, wasn't there a deposition scheduled very quickly that was supposed to be taking place? And so it seemed like, you know, if that was going to go forward, you know, you would have to have a pretty quick deadline on a mandamus response.
Well, the other side was well aware. We'd contacted the other side 3 weeks earlier to talk about mutual exchanges of expedited discovery, witness lists, exhibit lists, and we'd been coordinating with the other side for those depositions. I was actually getting ready to board a plane to El Paso because we'd even worked out where we were going to take the depositions. So we'd actually worked all of that out with the other side in the lead up to the depositions when this was happening. So anyway, just to give you a brief kind of preview into what was going on our side, but I will take that message back and share that with my colleagues. So pivoting back to the mootness issue. So we don't believe that the court needs to reach the issues of the temporary restraining order or the issues of expedited discovery because Texas is no longer seeking a temporary restraining order or a temporary injunction, permanent injunction. So there's no need to address those issues.
Are you familiar with this Hardwick case?
I am not, Your Honor. I believe this is the first time that it's been mentioned.
Yeah, just afterwards, we're very lax on post sub letters. Let us know if I'm may or may not, I may be mistaken about the difference between changing the facts and changing your claims, but let us know about that afterwards if you will.
Yes, Your Honor. And I believe the Hardwick was in reference to the venue provision. As it relates to the temporary restraining order and expedited discovery, again, it's moot. There is no need for this court to reach the issue of whether expedited discovery is appropriate because we don't need expedited discovery ahead of a temporary injunction hearing. We're not seeking a temporary injunction, nor is it necessary for the court to reach the TRO issue because we're not seeking a TRO anymore. Now, the other side has invoked the voluntary cessation as an exception to mootness in this case, but that doesn't really apply. The standard is whether it's absolutely clear that the challenged conduct is not likely to or reasonably likely to reoccur. Here, it's absolutely clear. It's absolutely clear because we've withdrawn those claims from our second amended petition. We filed an advisory with this court, and I'm here in front of the court representing that the state is not going to seek a TRO or injunctive relief in this case again.
So are you seeking contempt still? I take it.
So that decision it's a future decision. It's
But you're
speculative.
not disavowing, like contempt is could be sought potentially.
We are not disavowing it. We're simply saying that it's speculative because we have not made that ultimate decision. The case has not gone back down to the trial court. The trial court would then itself have to make a determination of whether or not the order is void. At this point, it's not void. The court has only stayed the
So as far
TRO.
as an emergency TRO, there's no emergency anymore.
There is no emergency anymore, Your Honor. In fact, we've obtained all of the injunctive relief that we sought in this case, which is why we withdrew our claims for injunctive relief. The legislators returned. The mid-decade redistricting maps passed. The special session ended. Those maps have even been upheld and allowed to go into place by the United States Supreme Court. And the relators are no longer engaged in the conduct giving rise to the claims in this lawsuit. It's not reasonably likely that there's going to be another special session to redraw redistricting maps and for which the relators are going to be doing fundraising. So because it's not reasonably likely to reoccur, and we're being absolutely clear that we're not going to seek a TRO or injunctive relief in this case, we believe that it's moot, and the court doesn't need to reach the merits of the TRO nor address whether it was void ab initio. That's a separate question, and it's speculative at this point.
And what's the venue for a quo warranto action?
Venue for a quo warranto action is typically.
Wait, I'm mispronouncing it. Maybe start there. Am I mispronouncing?
No, Your Honor, I think I always struggle with the pronunciation. So apologies if I call it Quaranto. That's just my accent and how I speak, but we mean the same thing. And I think that the court's interpretation or pronunciation is correct. As it relates to the Quaranto issue, that the typical venue provision for Quaranto is section 66.002, but that issue's been waived. In this case, we in our first amended petition, a couple of days before the motion to transfer venue hearing, we amended our petition to add the quo warranto claim. So the relators in this case were aware that we were seeking a quo warranto. They proceeded anyway to challenge the motion to transfer venue only as to the DTPA claims under 65.023 and 17.47. So the quo warranto issue and the venue as it relates to quo warranto is not an issue before the court today. Instead, venue is appropriate in this case for three reasons. First, because the operative pleadings in this case, that is the second amended petition, have withdrawn all claims for injunctive relief. So you never need to get to section 65.023 because that's a mandatory equitable injunction provision, but we're not seeking injunctive relief. Even if you were to go back and say that, well, the operative pleadings were the pleadings that were in front of the judge at the time, the trial court judge at the time she made the ruling, we still win. Why do we win? Because section 17.47 seeks an illegal injunctive relief, not an equitable injunctive relief. 65.023 relates to equitable injunctions, not legal injunctions.
Back up. It went past me quickly. I don't see a thing in chapter 66 of the civil practice that says what county has to be filed in. It says if grounds for remedy exist, the attorney general may petition the district court of the proper county. Doesn't say which one it is. And the odd thing is, in Annunciation House, the Supreme Court apparently went out of its way to says leave could similarly be denied for quo warranto if the face of the filing shows a violation of an unambiguous venue requirement. What are they talking about?
Your Honor, I don't think you need to reach that issue because we've already established venue under 17.47. That's the thing that's been appealed right now. That what's before the court is whether or not there was a clear abuse of discretion by the trial court when she made her ruling. And they never preserved this issue. They didn't even raise this issue with the trial court. So they're raising it for the first time now, and it's not even fully briefed before this court.
It was the first argument in their petition for mandamus, wasn't it? Transferring venue.
They're challenged to venue, Your Honor, but specifically as it relates to the quo warranto, which is a subpart. It wasn't brought up when we were in the trial court. They had the opportunity, they didn't bring it up. So we believe that they've waived it. Your Honor, I'll just add to the venue provision that in addition to the waiver as it relates to the quo warranto issue, venue's already been established. Here, section 17.47 is a legal injunction, and it's also the more specific statute. It should control over 65.023. If you were to find that 65.023 controls as a general equitable mandatory injunction venue provision controls over the more specific 17.47, it would result in the other provisions within 17.47 as surplusage. There's multiple grounds within 17.47 where we can establish venue, but none of those matter if 65.023 controls.
I'm still confused on if there's no disavowal of contempt, how do we not still reach the injunctive relief?
Well, Your Honor, you don't need to reach the injunctive or the temporary restraining order. In this case, you don't need to reach the temporary restraining order because their appeal of it goes to the merits.
But if it's void, doesn't that affect the contempt proceedings?
It would. If this court were to find that the temporary restraining order was void, then case law says we could not hold the relators in contempt for violating it if this court found it was void as an issue.
The reason why it wouldn't be.
That's not a reason why it wouldn't be moot. Just because there is a potential legal question doesn't mean that there's a live controversy related to the merits of the TRO before the court. Here, we're not seeking to pursue a TRO. So there's no contest between the parties as it relates to the temporary restraining order. Your Honors, I see that I'm out of time. We believe that the
And we're
court.
not gonna hold you in contempt. What, if you need to finish up 25 words or less, that's fine.
Thank you, Your Honor. Powered by People told donors that their money was going towards a lawful cause. It wasn't. That's a DTPA case. This case belongs in Tarrant County, and the petition for relators should be denied in its entirety.
You know, I need to ask one more question. Why isn't the amicus brief correct that this could easily be turned around against religious organizations that are doing fundraising? Why isn't that a valid point that if we go into the future and there's a different attorney general, let's say, that doesn't like what a religious organization is going to do with its money? Why aren't we in this same situation?
Well, Your Honor, I've got a couple of answers for the court. First, there is case law where we've pursued claims under the DTPA against against charities. And I gave the court the example of the Cancer Fund of America. That's an example where they were fundraising for purportedly a lawful purpose, but they weren't using those funds for the lawful purpose advertised to consumers. That was all 50 states under their individual state DTPAs and the FTC. As it relates to nonprofits, we've got the example of Mothers and Unborn Babies, which was a crisis management crisis pregnancy management entity. That's an example where we brought a claim against a nonprofit. That was a DTPA claim, and the Texas Supreme Court held that we could go forward with that. As it relates to, and the court talked about this a bit in its September 12th interim ruling, political contributions. And I want to flag that specifically and talk about that. This is not an example of a political contribution. Here, what we've got is a false, deceptive, or misleading statement under the guise of a political contribution. And the court noted that we didn't have any case law we could cite to where the DTPA had been enforced under similar circumstances. But I do have cases for the court that I can provide from other jurisdictions using their state DTPA laws. In 2023, WinRed, which is like the Republican version of Act Blue, which is a fundraising platform that's used by political candidates and political causes, the Attorney General of Minnesota and the Attorney General in Connecticut went after WinRed in 2023. They initiated state DTPA investigations into WinRed. WinRed argued that there was field preemption.
Why don't you just give us the site and we'll take a look at it?
Yes, Your Honor. Let me provide you with
And
this.
Judge Fields' question, and we'll give your opponents a little extra time as well too. It's a fascinating case. Judge Fields' question reminds me of Tilton versus Marshall, where you have a case where a guy, huge mega church, says, send us a contribution, we'll pray over these claws, and we'll send you the claws, and the miracles will happen. And the court says, number one, we can't get into whether praying over claws causes miracles. That's clearly hard of the First Amendment. What people want to believe that or not believe that is up to them. Said we're also not going to get into it because the argument was he never actually was praying over them. He just said he was, but wasn't actually doing it. Now that's just a flat out lie, but no, we can't get into that because this is religious, and this political speech kind of has that same feeling. We're not going to get into this because it's the line between what's a personal expense and what's a political expense is a dangerous one to try to draw. And as you know, the big thing in prior speech cases is we don't want to chill it. Chill it means that's what we do when there's no bright lines. And I mean, it feels a lot like that's a Tilton versus Marshall situation.
Oh, well, Your Honor, here we're not trying to chill speech. We're just trying to make sure that the speech that is provided is accurate. They can't lie about what they're going to use.
Some First Amendment protection, even for
Lies.
untrue speech, right?
Well, they're
Right? I mean, does the First Amendment extend to some untrue speech?
Your Honor, we have cited to case law in our brief, and I'm happy to provide it right after I provide the WinRed citations that says that false and deceptive speech and as it relates to trade and commerce is not protected by the First Amendment. Let me give the court the WinRed citations. That's the Connecticut Superior Court. That was 2023 Westlaw 4322714. And then for the Eighth Circuit Court of Appeals, that is WinRed v. Ellison 59F 4th 934. It's in the Eighth Circuit Court of Appeals that found that These donations on the WinRed platform to political candidates and political campaigns fell within the state DTPA statutes because they were clearly false, deceptive, or misleading acts or
Got it.
practices within trade and commerce.
Thank you,
Your
Mr.
Honor.
Stone. Let's give Mr. Gonzalez 10 minutes. Won't hold you in contempt either if you run slightly over that.
Appreciate it. So starting on this last point, in addition to the Tilden case, this is a case we cite in our reply brief at page 17, Word of Faith World Outreach Center Church versus Morales. And this was a Western District case construing the DTPA. And the Fifth Circuit reversed on other grounds, but Justice Smith did write that it was doubtful that the DTPA even applies to this type of religious activity. And the cases that that the state is citing, mother versus unborn child, there it involved the advertising of specific, concrete, identifiable medical services. It wasn't general fundraising for charitable purposes. And WinRed as well is a service provider in the vein of Act Blue. Then in terms of the mootness, the state keeps changing its position, amending its pleadings in order to try to play games with the court's jurisdiction, which was precisely the case in In Re Allied Chemical. And the Supreme Court, stated that parties cannot manipulate jurisdiction in that way.
But here, I mean, is it really manipulating jurisdiction when everything they were trying to stop has stopped of its own accord?
Well, Your Honor, in terms of if it goes to the intent sort of, we point this court and we I think provide citations in our letter, but we actually raised this issue in asking the trial court to dissolve the TRO. We argued that the quorum break was over, the redistricting law had passed, there's no need for any restraint. And the state said that categorically a restraining order under the DTPA cannot be moot. And that's, based on the statute, but they took the opposite position that they're taking now that they've had a preliminary ruling against them. And on the collateral consequences issue, and that's the name of a doctrine about mootness, collateral consequences, to also point the court to In Re Salgado, which is 53 Southwest 3rd, 752, and Phillips v. Phillips, 651 Southwest 3rd, 112. Also the In Re Cornyn case I mentioned earlier. And those cases, even when there isn't, in the last two, the In Re Salgado and Phillips case, there wasn't a pending contempt motion, but the mere, sort of, it was a parent-child case, and the continued disdain, I forgot the exact term they used, but that having the ruling in place would cause to the person who lost that ruling was sufficient collateral consequences to make the ruling. In Re Cornyn deals with where there's an actual pending contempt motion.
Why isn't that speculative, though, if they haven't made a decision, maybe contempt, maybe not? I mean, why isn't this something that's too soon for us to deal with? And maybe everyone would have to come back later.
They haven't withdrawn the contempt motion and, haven't indicated that they would. And voluntary cessation, I don't have the exact language, but it requires an affirmative denial. And that's also, I think, in our letter response to the state. Additionally, the quo warranto proceeding, and that's, in their second amended petition, they're seeking quo warranto based on alleged violations of the temporary restraining order. And to answer Your Honor's question, courts read the quo warranto venue statute to be proper county as the general venue provision. So 15.002 is what courts apply for quo warranto. But importantly, the state or district attorney can't just file quo warranto. They need leave to even file it. So there is no, there hasn't been a motion to transfer
But
venue.
is the
on
quo
quo-
warranto venue issue even properly before us at this point?
It is not, no, Your Honor. And also on the voluntary cessation point, even if the court, even, you were to argue that the case is moot, when the mootness is caused by the prevailing party's own actions, vacatur is still the proper remedy. And I'd point the court to Marath v. Lewis on that issue. On the pin site, but it's a Texas Supreme Court case, Marath v. Lewis. But here, because there are collateral consequences of contempt, this court should also declare that the order was void. As this court, Your Honor, asked about evidence, and I believe opposing counsel talked about the temporary restraining order being based on verified pleadings. But as this court pointed out in its preliminary order, allegations still can't be conclusory, and the court's findings can't be conclusory. And that was all that was cited to in the pleadings was conclusory allegations such as, held this out to be lawful or engaged in unlawful personal expenditures. There's no actual evidence or even concrete factual allegations. Also, I think it's worth clarifying because this has come up a couple of times. Leave it there, but the state continues to bring up this F the rules statement. And I think it's sort of extraordinary. We played the whole transcript in front of the trial court. We've provided your honors with the complete quotation in footnote 5 in our reply brief. But the F the rules is part of a statement about redistricting where Mr. O'Rourke says, they're redistricting in Texas. We need to redistrict in California. They've thrown out the rules. We need to say F the rules as well. It had absolutely nothing to do with the court's temporary restraining order. In terms of the advertising and distributing, again, distributing, they say distributing a thing of value, but the basis of the claim has to be the consumer transaction or the transaction in trade and commerce. Even if they say trade and commerce versus consumer, it's still the same sort of body of commerce and business, exchange of value, of valuable things. If the court has no other questions, Your Honor.
Anything? Thank you, Mr. Gonzalez.
Thank you.
Very generous giving us the 2 minutes back. We appreciate it. Court will be in recess for a brief period and then be back for the second case.
All rise.